Editing is important for any written communication so that it is void of grammatical errors, clear and promotes readability, and any outside references are cited correct and accurately. This is especially true for legal editors, since the repercussions of poor legal writing can be severe. Legal docs carry the weight of determining an individual's future. For example, if a firm is representing a client who is wrongly convicted of a murder, the repercussions of poor legal written documents can potentially send an innocent person to jail for the rest of their life. So the stakes are extremely high when it comes to legal editing. However, what is a legal editor? Well, according to a section published on Maryville University's website titled How to Become a Legal Editor, they are responsible for copy and content editing, proofreading, and fact-checking. This consists of inter-office written communication, such as a policy memo, a PowerPoint presentation, or a email chain. And this also consists of external documents that will be submitted to external sources such as courts or clients. And these types of documents can include a formal complaint or judgment entry, and also a brief on a case. So legal editors must have a thorough understanding of legal terminology and legal language. Legal language is the English language with more words rooted in ancient British origin with a high concentration in the Anglo-Saxon origin. For example, Peter Tiersma in his book Legal Language states, an Anglo-Saxon legal term that is still extant but without its original legal meaning is doom. Doom is related to the word deem, the same way moot is related to the word meet. To deem is to render judgment. This word is still widely used today, and in fact is integral to legal documents that a party in a case files against another party in order to seek judgment. The extent to which legal language is used will vary depending on the audience of the writing. So, for example, in academic papers, it's easy to identify the audience. It's usually the professor and occasionally students for peer review. And the relationship between the professor and the student goes as such, where the professor assigns an assignment and creating work for the student. The student then submits the finished assignment to the professor, creating work for the professor, so they can both adequately do their job. The same goes for legal documents. The attorney sends drafts of legal documents to the editor. The editor will then edit them and send their changes to the attorney. The attorney will then review them, send it to the clerk of courts. The clerk of courts will read it, file it accordingly with the correct court, and send it to the judge. The judge will then read it and then render an opinion or an action. Since each audience member has a unique purpose for the doc, the writing must appeal to all. For example, writing should be clear and readable for the clerk to file accordingly, and the writing must be factual, correct, and precise for the judge to render a correct and articulate decision on the case. Laurie Curry Oates, in her book, The Legal Writing Handbook, further solidifies this point by stating, you are writing to real readers, readers who need your writing with all of its research, analysis, arguments, citations, conclusions, and insights in order to do their jobs. This further demonstrates the gravity of good writing, since the ability to do one's job is on the line. Once an editor has identified who the audience is and what language to use, they can begin editing. So according to the American Bar Association's website, they recommend following the Chicago Manual of Style for grammar and punctuation, and the Webster's Collegiate Dictionary for spelling. However, citations need a completely different style guide, and the most common is the Blue Book. This deals with the correct citation of state and federal statutes, and statutes work the same way as references in an academic paper. They are support of your argument or your thesis being stated. The proper way to cite a federal statute to begin with, the Blue Book recommends, if possible, cite the official code, the USC. If not, cite the unofficial code, which is USCA or USCS, which stands for United States Code Annotated or United States Code Service. The name of the statute appears first, followed by a comma, followed by the title, code, and then the sections. State statutes are much easier. but they can differ state by state. But the most common is just the code and then the section. So in this case, it is Ohio Revised Code, or ROC, section 5721.32. So we briefly talked about the past and the origins of legal language, the present, and the steps the editor takes to begin editing. Now we'll discuss a possible avenue for legal writing to take in the future. Language is always changing with time, and some fields of writing are better at adapting to these changes than others. And then there's legal editing, which has ceased to change since centuries. Kevin M. Curra, practicing attorney in Dallas, Texas, published an article titled "A New Approach to Legal Editing" and identifies an issue about the outdated language. The problem is college curriculums have eliminated writing requirements, and law schools have never offered courses of contact drafting. At best, the writing component consists of oral advocacy and legal brief writing, which means there is no uniform style of writing taught in law schools and in firms across the country, which makes it open to interpretation for how these firms and how these students internalize their own style guide and what to use, which can create massive confusion, especially for new employees in firms across the country. To accommodate this lack of preparedness, Kerr suggests that firms update their document templates to adhere to more plain English standards. What he means by templates is that since I work at a law firm, I have experience with legal editing, and when I am presented with creating a document, say I am to generate a complaint or form a judgment entry, I do not start from scratch. There is a template in the database that we use throughout, which has some of the same language, except you incorporate facts of the individual case, and all I'm responsible for is correcting formatting and some punctuational changes. What he's suggesting is that law firms across the country are more consistent with changing them, adhering to a more modern approach. So that means just incorporating language that lay people can more easily understand, and to avoid confusion with new employees who just graduated law school, so they can work more effectively towards an assignment, since it's not being widely taught in law school curriculums. Anna Zabota discusses more technical changes to legal drafting in her article, The Plain Language Movement in Modern Legal Drafting. Structural changes can include simpler and logical sentences, reduction of sentence length, which is a big one, since there are many run-ons, some in the form of an entire paragraph, and avoid double negatives. Grammatical errors. There's a stress placed on active voice versus the passive voice, because active is more straightforward. Passive kind of can get lost in translations, especially with the use of legal language. And then the use of more present simple tense is always recommended as well. Word usage, avoiding jargon and use precise verbs. Jargon is littered, and it's just a way to beef up the language and for attorneys and judges to come off more articulate. There's really no need for all the littered jargon. It's just, like I said, to make the writer appear more articulate. There's really no need for that. You can create the same sentences and get the same point across using plain English standards as opposed to legal jargon. This transition will positively impact the editor in relation to their jobs. The workloads will reduce, as well as the pressure, since plain English is easier to grasp. So, you still want to be a legal editor? I'll leave you with a quote. A small error can have a big impact. Nowhere is this more true than legal writing. A small error may prevent the reader from understanding the document. It may negatively impact the intended beneficiaries of the document, and may undermine the authoring attorney's professional reputation. There are no bad days, no slip-ups for legal editors when the consequences are so severe for poor writing. Um, that alone should be at the forefront of every editor's mind, especially when it comes to legal editing, since the repercussions are too great for poorly written, poorly edited documents, and the playing with someone else's life. So that's a legal editor. Thank you.